Welcome to today's program, Multijurisdictional Practice, Avoiding the Unauthorized Practice of Law. My name is Zach McGee. I'm the Senior Vice President and Head of Business Affairs for Sony Pictures Home Entertainment. Before I moved into a business role in entertainment, I was a law firm litigator, first at Davis Polk in New York and later in the firm's Menlo Park, California office, and then an in-house litigator at NBC Universal here in Los Angeles. After that, I held transactional legal roles, first at NBC Universal and later at Miramax, where I continued to advise clients on legal issues arising from the development, production, and distribution of film and television content. Throughout my career as both a law firm and in-house lawyer, I have frequently been asked to advise clients located throughout the United States, not just in California and New York, where I am a member of the bar, but in states like Nevada, Texas, and Virginia, among many others. As a result, the issues raised by multi-jurisdictional practice are ones that I've researched and thought a lot about in my legal practice. Even if most of the legal work you do is for clients in your home state, chances are that in today's world, you're going to be asked to give advice to clients about transactional or litigation matters that arise in other states, or in some cases, to advise clients located in other states, if you haven't been asked to do some or all of that already. For that reason, it's important to know the rules that govern multi-jurisdictional practice and the unauthorized practice of law to make sure that you always stay on the right side and never on the wrong side of those rules, because breaking them can have serious reputational, financial, legal, and ethical consequences for lawyers. We're going to do a couple of things today. First, I'm going to provide a brief introduction to the unauthorized practice of law, including taking you through the facts and holding of a seminal case in this area, the California Supreme Court's decision in Burbrower v. Superior Court. When that case came down, it struck so much fear into the hearts of lawyers nationwide that it prompted the American Bar Association to study the myriad issues that are raised when lawyers seek to perform legal services across state lines, and to propose a comprehensive set of ethics rules that now govern what lawyers can and can't do that have been adopted in some form by nearly all of the states and the District of Columbia. Second, we're going to talk about those ethics rules in detail, which are ABA Model Rules 5.5 and 8.5 that reflect the ABA approach. In case you were worried that studying ABA model rules might be a waste of your time, I'm pleased to inform you that as of May 2016, ABA Model Rule 5.5 has been adopted without changes in 13 states: Alaska, Arizona, Illinois, Indiana, Iowa, Maryland, Massachusetts, Nebraska, New Hampshire, Rhode Island, Vermont, Washington, and West Virginia. As of October 2014, ABA Model Rule 8.5 has been adopted without changes in 24 states: Alaska, Arizona, Arkansas, Connecticut, Delaware, Idaho, Illinois, Iowa, Kentucky, Louisiana, Michigan, Minnesota, Missouri, Nebraska, Ohio, Oklahoma, Oregon, Pennsylvania, Rhode Island, South Dakota, Utah, Vermont, Washington, and West Virginia. What's more, in addition to the states that have adopted these rules verbatim, an additional 34 states and the District of Columbia have adopted a rule similar to Model Rule 5.5, and an additional 21 states and the District of Columbia have adopted a rule similar to Model Rule 8.5. So this means that if you live in any state except Alabama, Hawaii, Kansas, Mississippi, Montana, and Texas, and if you learn Model Rules 5.5 and 8.5, you'll be pretty well covered, which is great news for today's lawyers. I would be remiss if I didn't pause briefly to contrast today's regime of nearly uniform rules with 20 years ago, when we had substantial uncertainty over what, if any, legal practice outside your home state was permissible. While the ABA doesn't always get things right or make the practice of law less complicated, we should credit them in this case for promulgating Model Rules 5.5 and 8.5 and persuading the vast majority of states to adopt them in some form. Next, even though both California and New York are among the states that have adopted rules similar to Model Rules 5.5 and 8.5, we're going to spend some time reviewing the rules in those states in detail for two reasons. First, many lawyers, like me, are licensed to practice in one or more of those two states, so it will benefit a lot of lawyers to know the specifics of those rules and what they require of lawyers who are governed by them. Second, pursuant to the terms of ABA Model Rule 8.5, which nearly all states have adopted in some form, a lawyer who performs legal services is not only subject to the legal ethics rules of the state in which he or she is licensed, but also in any state where the lawyer, quote, provides or offers to provide legal services, end quote. Because many lawyers are called upon to advise clients located in California and New York, no matter where the lawyer is located, It's important for those lawyers to know the legal ethics rules that may be applied to their representation of California or New York clients under those states' equivalents of Model Rule 8.5. Finally, we'll consider what obligations apply to a lawyer who associates with or is sponsored for pro hoc vice admission by local counsel in a state where he or she is not admitted for the purpose of performing legal services in that state, and conversely, what obligations apply to the local lawyer who is associating with or sponsoring for pro hoc vice admission the out-of-state lawyer. While it's never okay for the local lawyer to sponsor an out-of-state lawyer, if the sponsoring lawyer has no involvement in the matter on which the out-of-state lawyer will work, the ethics rules require quite a fair bit more than mere involvement in both the sponsored and sponsoring lawyers need to be aware of those requirements. Before we get started, why should you care about multi-jurisdictional practice? After all, what's the worst thing that could happen to a lawyer who is found to have engaged in the unauthorized practice of law? Well, the parade of horribles is actually quite long and distinguished, and they fall into four main categories of nasty consequences: reputational, financial, legal, and ethical. Let's start with your professional reputation. Short of failing the bar exam, and most everyone knows that the former dean of Stanford Law School, Kathleen Sullivan, famously failed the California bar exam, as did current United States Senator from California, Kamala Harris, and current California Governor, Jerry Brown, and that the former First Lady, Michelle Obama, failed the Illinois bar exam. Getting caught practicing law without a proper license is probably the next worst thing a lawyer can do to tarnish his or her professional reputation. In fact, some years ago, the National Law Journal published an expose entitled "GCs Forget One Detail, Their License," where they famously outed 8 general counsel of Fortune 500 companies who were not properly licensed to practice law in the state where they worked. You certainly wouldn't want to find yourself on a list like that. Apart from your reputation, being found to have engaged in the unauthorized practice of law can have serious financial consequences. While you can be fined for violating a state's unauthorized practice of law statute, in a civil action or as part of a state bar disciplinary proceeding, lawyers can suffer much larger financial penalties by being denied the ability to collect fees for legal work they performed if they are held to have practiced law in a state without a proper license. In the Burbrower case I mentioned earlier, the California Supreme Court denied a New York law firm the right to recover over $1 million in legal fees under a fee agreement that the court found was illegal, to the extent it obligated the client to pay for legal services the firm rendered in California, where it was not authorized to practice law. In a more recent case, the California Court of Appeal in Golba v. Dick's Sporting Goods denied an Illinois law firm's fee application for over $200,000 in a court-approved settlement of a consumer class action. Because the Illinois law firm's lawyers had failed to secure pro hoc vice admission in the case, the court found that they were not authorized to practice law in California and thus were not entitled to any legal fees related to that representation. As these cases show, loss of legal fees can be a huge financial consequence to a finding of unauthorized practice of law. The legal consequences for the unauthorized practice of law include civil liability for violating unauthorized practice of law statutes, as well as making claims of malpractice by dissatisfied clients more likely to succeed if the lawyer was not authorized to practice law in the state where the client resided. A finding of unauthorized practice of law also means that the client loses the protection of the attorney-client privilege with respect to communications between the lawyer and the client. In the view of the courts that have considered these cases, the result is binary. Either you are a lawyer properly licensed to practice in the state, in which case the attorney-client privilege attaches to your communications with your client, or you are not a lawyer properly licensed to practice in the state, in which case there is no privilege. No middle ground exists for cases where the client or the lawyer made a mistake of fact or law about the lawyer's right to practice law in the state. It's all or nothing, and you can imagine how unhappy and litigious a client can be who's been forced to disclose communications with his or her lawyer that the client reasonably thought were privileged. Finally, there are the legal ethics consequences of having engaged in the unauthorized practice of law, which include potential state bar sanctions of a fine, suspension, and disbarment. As we will see later, in nearly all states, a lawyer now can be subject to discipline in at least 2 states, the state where he or she is licensed, and any of the states where he or she performed legal work, so the potential sanctions are effectively multiplied by the number of states involved. In a recent example, a lawyer who was licensed to practice in California was disbarred in 2017 by the California State Bar for having held himself out as entitled to practice law in Maryland and Illinois, and for having collected illegal fees in those matters. The legal ethics rules in Maryland and Illinois now allow those states to sanction this same lawyer for his conduct, which in this case could include an order preemptively barring him from becoming a member of the state's bar should he ever attempt to do so. These states could impose such a sanction either based on the lawyer's conduct that occurred in their states or simply in an act of reciprocity in response to the California State Bar's order disbarring the lawyer, which is common when one state disbars a lawyer. However you slice it, and whichever of these consequences you would most like to avoid, reputational, financial, legal, or ethical, you simply do not want to be on the wrong side of an unauthorized practice of law finding. Over the next hour, we'll give you the information and guidance you need to avoid that unhappy result. Let's get started with our brief introduction to the unauthorized practice of law. How did we come to these unauthorized practice of law statutes? In the early 1900s, states began enacting laws barring lawyers not admitted in a state from practicing law in that state. And there were a couple of objectives behind these statutes. The first was to make sure that clients in that state received competent representation. The idea was that out-of-state counsel might not be as familiar with the laws of that state and might not be able to provide the same level of quality representation as in-state lawyers. The second rationale for these statutes was to protect the economic interests of lawyers who practice in a state. So taking California as an example, by enacting an unauthorized practice of law statute, the California legislature was motivated in part by a desire to protect California lawyers from lawyers in Nevada or Washington or Oregon coming in and taking clients and work away from California lawyers. Not surprisingly, the vast majority of the members of the California legislature were themselves lawyers, which I'm sure will not surprise you. Now, when these laws were initially on the books, and I would say for the first half century, they didn't have a lot of impact because in those days, most law practice really was local. You can imagine thinking about a lawyer from that era. He would have been sitting in his office, and I say he because in that era all lawyers were men, and he would have his law books lined up on his shelves. Any issue that would come up, this lawyer would handle it, as opposed to now where you would have an issue that comes up and you may choose to reach out to counsel that has a specialty in whatever the issue was. In those days, each lawyer was a jack of all trades. He would handle bankruptcy matters, contract matters, family law, litigation, you name it. And the lawyer would do it all from a local perspective. The lawyer's clients would be the people in his town or in a nearby town, but almost certainly people who lived in the same state as the lawyer. As a result, you really didn't have a lot of representation of out-of-state clients or representation with respect to matters arising in other states by lawyers in those days. By the mid-1900s, technological advances allowed many companies to expand both nationally and internationally. That meant for the first time, most companies had offices, suppliers, customers, and competitors located throughout the United States, and in the case of larger companies, throughout the world. Today, attorneys who represent those companies are routinely asked to give advice, negotiate contracts, and deal with disputes that involve clients or counterparties located in other states. These technological advances not only made communication between lawyers and clients easier. We now have telephone, Skype, email, and text messages, in addition to traditional mail and in-person meetings. But it has made legal research and the flow of information that lawyers need for their practice much easier too. So, unlike the lawyer I was hypothesizing in the beginning, where he would sit down with one of the treatises on his bookshelf and research an issue, we now have Lexis and Westlaw. Any issue that comes up, if you're a California lawyer and you need to look up a Washington statute or a case from Oregon, it's very easy to do that, whereas in the past you wouldn't have had access to those authorities because you wouldn't have had a set of Washington statutes or an Oregon case law reporter on your bookshelf. For litigators, technology now also allows lawyers to litigate matters in courts located in other states with electronic access to court dockets like the PACER system in the federal courts that allows litigators to search court dockets and to find, retrieve, and file documents with the court. In many cases, court appearances can be made by telephone or video conference, eliminating the need to travel for routine appearances. For their part, transactional lawyers have access to online services like the Edgar system for the retrieval and filing of documents with the SEC, and to other similar databases, as well as to the internet in general, that allows all lawyers to perform research on people, companies, and real property that they need to draft and negotiate contracts, prepare complaints, and otherwise perform legal work for their clients. The alternative to having your lawyer in your state handle a matter for you that's pending in another state is to hire another lawyer in the other state, and that's an inefficient and costly process. Your clients can take advantage of many efficiencies if they can use the same lawyer who's already familiar with their company, their objectives, and the relevant facts to represent them in the other matter. If your client had to bring in another lawyer, either you or the client would have to bring that lawyer up to speed on everything that you already know, which is costly and time-consuming. What's more, the game of telephone that frequently results when someone is passing along information and instructions to the lawyer in the other state opens the door to misunderstandings and mistakes. Even if everything gets communicated correctly, at a minimum, your client is signing up to another layer of lawyers, another layer of inefficiency, and another layer of costs. As a result, you had more and more clients saying to their lawyers, "Can't you handle this new matter for me? I don't want to incur the cost of bringing in another law firm." And more lawyers agreeing to do it, even though the legal authority for lawyers in those days to practice law outside of the state in which they were licensed was at best uncertain, and at worst non-existent, making it illegal and unethical to engage in such practice. Nevertheless, by the mid-1900s, you had more and more lawyers handling matters for clients that arose outside the states in which they were licensed, which put the legal profession on a collision course with the unauthorized practice of law statutes we discussed earlier. By the late 1900s, state bars became more aggressive in enforcing these statutes, but the path to stopping lawyers from practicing law in a state where they were not licensed wasn't that clear either. First of all, what authority did state bars have back then to discipline lawyers who were not members of that state's bar? If you were a California lawyer and you were doing legal work in Nevada, and the Nevada State Bar wanted to enforce its unauthorized practice of law statute against you, what jurisdiction did they have over you? You were not admitted in Nevada, so the normal sanction of being able to impose discipline on the members of your state's bar wouldn't be available to Nevada in that case. Even if the Nevada State Bar decided to exercise jurisdiction over the California lawyer and found him or her guilty, what sanction could the Nevada State Bar impose under the legal ethics rules that were in effect in Nevada at the time? Normally, you could suspend, fine, or disbar a lawyer who violates your state's ethics rules, or its civil or criminal statutes. But in our hypothetical, and before the ABA stepped in with the new ethics rules that clarified issues of jurisdiction once they were adopted by nearly all of the states, including Nevada, the Nevada State Bar probably could not have done anything to a California lawyer who never consented to be subject to the discipline of any state besides California. Now, it turns out that the unauthorized practice of law statute in Nevada makes it a misdemeanor to engage in the unauthorized practice of law, but that's not the case in roughly 1/3 of the states where the unauthorized practice of law is a violation of the civil law, but not a crime. While it's certainly possible, even back then, that the Nevada State Bar could have referred an unauthorized practice of law matter to the Nevada Attorney General for possible criminal prosecution, in every case I've seen, criminal prosecutions for the unauthorized practice of law are reserved for cases where someone is practicing law without holding any license, i.e., non-lawyers holding themselves out to be tax or immigration lawyers who charge vulnerable clients high fees for dubious advice. What you don't see is out-of-state lawyers being prosecuted criminally for the unauthorized practice of law, unless there's something much more nefarious also going on. So how were unauthorized practice of law cases making their way to the courts if state bars didn't have clear authority to bring them, and if state prosecutors weren't filing criminal charges? The answer is unhappy clients started raising the unauthorized practice of law as a defense in cases where their lawyers were suing them for fees they claimed the clients owed. So in our hypothetical, when the Nevada client ended up being unhappy with the work of the California lawyer, among the grounds the client would raise in refusing to pay for the legal work is that the California lawyer was committing unauthorized practice of law in Nevada. This is exactly the kind of dispute, this time involving a New York law firm and a California client who was unhappy with the firm's work, that precipitated the seminal decision in Burbrower v. Superior Court. It's just one example, but the most famous example, of an unauthorized practice of law case that prompted the ABA to study the issues that come up with a whole new set of ethics rules that now govern multi-jurisdictional practice in nearly all 50 states and the District of Columbia. Given its prominence and the terrorizing effect it had on the legal profession, you would think the California Supreme Court's holding in Burbrower swept far broader than it actually did. In fact, the holding of the case was limited to the following facts. The New York law firm of Burbrower, Montalbano, Condon, and Frank, whose lawyers were not admitted in California, engaged in the unauthorized practice of law by performing legal services in California under California law for a California client. The remedy that the court imposed was that it invalidated Burbrower's fee agreement to the extent it authorized payment for the substantial legal services that were performed in California. What's most interesting about this case, and I think you can see from the holding there, was a lot of California conduct going on. The New York law firm did a lot of things directed at California, and while physically located in California, as part of their representation of this California client. The facts make it clear that Burbrower lawyers traveled to California to meet with employees of the client and its accountants to discuss their strategy. The Burbrower lawyers also met with third parties in California, specifically lawyers who represented the other side in the dispute, to discuss a potential settlement of the matter. The Burbauer lawyers even filed a demand for arbitration with AAA in San Francisco and started down the road of interviewing potential arbitrators to preside over that arbitration matter. I think the take-home message is that the Burbauer lawyers spent a lot of time physically in California doing legal work, and when they weren't physically present in California, they were making contact by telephone and fax with their client, the lawyers representing the other side in the dispute, and the AAA organization, all of whom were located in California. According to the California Supreme Court, the practice of law, quote, in California, end quote, for purposes of California's unauthorized practice of law statute, requires sufficient contact with a California client to render the nature of the services a clear legal representation. The court stated, quote, the primary inquiry is whether the unlicensed lawyer engaged in sufficient activities in the state or created a continuous relationship with the California client that included legal duties and obligations, end quote. The court said that, quote, mere fortuitous or attenuated, end quote, conduct with California or a California client is insufficient for an unauthorized practice of law finding. The court also held, and this is the part of the decision that caused the most concern, that, quote, our definition of unauthorized practice of law does not necessarily depend on or require the unlicensed lawyer's physical presence in the state. Physical presence here is one factor we may consider in deciding whether the unlicensed lawyer has violated Section 6125, but it is by no means exclusive, end quote. As if that wasn't scary enough, the court continued, quote, one may practice law in the state in violation of Section 6125, although not physically present here, by advising a California client on California law in connection with a California legal dispute by telephone, fax, computer, or other modern technological means, end quote. So in Burbauer, you have the highest court of the country's most populous state saying that a lawyer who has never set foot in California can be found to have engaged in the unauthorized practice of law in California if he or she advised a California client by telephone, as long as those contacts were sufficient to create a continuous relationship with the California client that included legal duties and obligations. In other words, the California Supreme Court was saying that a lawyer's virtual presence in California, by telephone, fax, or other technological means, which in today's world would include email, Skype, and text messages, can lead to an unauthorized practice of law finding, but without specifying exactly how much virtual presence is sufficient for such a finding. Even though this part of the court's opinion was clearly dicta, as noted, the Burbauer lawyers were physically present in California on multiple occasions and had conducted most of their legal work in person in California. It is fair to say that the court's words scared the hell out of lawyers nationwide because you have many millions of people and businesses located in California and many millions of lawyers in other states who are having contact on a daily basis with those people and businesses. As scary as its sweeping language was, the California Supreme Court's decision was limited in certain key respects, either expressly by Burbauer or by later cases raising similar issues, that did provide some measure of comfort to out-of-state lawyers. First, in a subsequent case, Condon v. McHenry, the California Court of Appeal held that non-California clients are not covered by the court's decision in Burbauer. So, if you're doing anything while physically present in California or engaged in activities directed at California, but the client that you're representing is not a California client, you are not engaged in the unauthorized practice of law in California. The rationale for this distinction is that the California legislature, in enacting its unauthorized practice of law statute, only intended to protect California clients from the unauthorized practice of law and not clients located in any other state. Second, if a lawyer is practicing California law, but there is no other connection to California, he or she cannot be engaged in the unauthorized practice of law in California. Why does that make sense? Let's say you are a lawyer in Washington State who represents a client in Washington State. The client is thinking about selling its product in California for the first time, and the client asks you to take a look at California law on a particular subject. If you're representing a Washington State client, there's no other connection to California other than you're researching whatever California law would be on a particular issue. The California Supreme Court in Burbauer made it clear that you're not going to have an unauthorized practice of law problem just for doing research or just for writing a memo that includes a survey of California law. Third, the California Supreme Court excluded federal practice from its holding in Burbauer. Even if the California Supreme Court had wanted to, it could not regulate the practice of law in the federal courts, because those courts exist by the authority of the United States Constitution and federal law, and the Supremacy Clause prohibits states from regulating them. While this distinction is important legally, it no longer has any practical effect because all federal courts in California now require lawyers who seek admission to practice in those courts to be members of the California Bar. If you seek to practice in California federal court, you either need to be admitted to practice before that court, which, as noted, requires California Bar membership, or you need to be granted permission by the federal court to appear pro hoc vice. Despite these limitations, and due in large part to its scary dicta about lawyers who have never traveled to California, but who nonetheless could be held to have engaged in the unauthorized practice of law in California, the California Supreme Court's decision in Burbrower set off a panic among lawyers nationwide that spurred the ABA to act quickly, or at least quickly for a group made up exclusively of lawyers. In June 2000, the ABA formed a subcommittee to study multi-jurisdictional practice issues, and just 2 years later, in August 2002, the Commission's report and recommendations, which included amendments to ABA Model Rules 5.5 and 8.5, were adopted by the ABA. Today, a total of 46 states and the District of Columbia have adopted Model Rules 5.5 and 8.5 or similar rules. As noted, if you practice in any state other than Alabama, Hawaii, Kansas, Mississippi, Montana, and Texas, you will be pretty well covered if you learn Model Rules 5.5 and 8.5. That said, if there is a particular state in which you are not admitted and in which you plan to perform significant legal services for a client located in that state, I recommend that you research the rules that apply in that state just to be aware of any differences from Model Rules 5.5 and 8.5. California and New York are good examples of two states that have adopted rules similar to Model Rules 5.5 and 8.5, but where there are some differences. While it's not worth taking the time to look at the rules of all 46 states and the District of Columbia, it probably is worth your time to focus on the couple of states where you have clients to ensure that your conduct conforms to the particulars of those states' rules if they didn't adopt Model Rules 5.5 and 8.5 verbatim. In your materials, you will find helpful charts showing you which of the 46 states and the District of Columbia have adopted these rules verbatim and which have adopted similar rules, and providing you with citations to the applicable rules in all 46 states and the District of Columbia in case you wish to review any of those rules in detail. Focusing on the model rules, let's take a look at what those rules provide. Model Rule 5.5c states that, quote, "A lawyer admitted in another United States jurisdiction and not disbarred or suspended from practice in any jurisdiction may provide legal services on a temporary basis in this jurisdiction that, 1, are undertaken in association with a lawyer who is admitted to practice in this jurisdiction and who actively participates in the matter, 2, are in or reasonably related to a proceeding or potential proceeding before a tribunal in this or another jurisdiction, if the lawyer, or a person the lawyer is assisting, is authorized by law or order to appear in such proceeding or reasonably expects to be so authorized. 3, are in or reasonably related to a proceeding or potential arbitration, mediation, or other alternative dispute resolution proceeding in this or another jurisdiction, if the services arise out of or are reasonably related to the lawyer's practice in a jurisdiction in which the lawyer is admitted to practice and are not services for which the forum requires pro hoc vice admission, or 4, are not within paragraph C2 or C3 and arise out of or are reasonably related to the lawyer's practice in a jurisdiction in which the lawyer is admitted to practice." End quote. Before we get into the specific parts of Rule 5.5c, it's important to recognize what a step forward Rule 5.5 was when it was first adopted by the ABA and later by the individual states. For the first time in American legal practice, you have a rule that affirmatively allowed a lawyer to practice law on a temporary basis in a state where he or she is not admitted. Prior to Rule 5.5c, there was no such authority, and all such law practice was undertaken at the lawyer's risk, like the New York lawyers who were denied their legal fees in the Burbrower case. This was a huge step forward for lawyers and their clients, and we should thank the ABA for driving this change. Now, Rule 5.5 does not give lawyers carte blanche to practice law outside their home states, even on a temporary basis. And you can think about the policies behind the unauthorized practice of law statutes we discussed at the outset as the main reasons why. You can have a healthy debate about whether the desire to protect in-state clients and/or in-state lawyers remain valid objectives in today's world, but the fact that these concerns still exist explains why neither the ABA nor the individual states who have adopted Model Rule 5.5 were willing to go further than they did in authorizing lawyers to practice across state lines. So the result is that a lawyer's ability to practice outside his or her home state on a temporary basis is limited to 4 specific categories that are set out in Model Rule 5.5C1 through 4. The first category in Model Rule 5.5C1 is when the out-of-state lawyer associates with a lawyer in the state who actively participates in the matter. This category is available to both transactional lawyers and litigators, and it gives out-of-state lawyers the ability to perform legal services for in-state clients as long as an in-state lawyer is representing the client as well and is playing an active role in the transaction or litigation matter. Because of the requirement that the in-state lawyer also represent the client and actively participate in the representation, you might wonder how helpful this category really is for the client if the client is concerned about duplication of effort and costs. Is it really better for the client to have 2 lawyers, the out-of-state lawyer and the in-state lawyer, representing it in the matter versus just the in-state lawyer who can be brought up to speed by the out-of-state lawyer? If you are cynical, the option for out-of-state lawyers to associate with in-state lawyers sounds like a better deal for both sets of lawyers than the client. The second category is Model Rule 5.5C2, and it's limited to litigators, and it allows representation of a client in this state if the representation relates to a matter in this state in which the lawyer is authorized to appear, i.e. admitted to that court's bar or admitted for that matter pro hoc vice, or to a matter in another state in which the lawyer is authorized to appear, i.e. admitted to that court's bar or admitted for that matter pro hoc vice. By way of example, if you are a California lawyer and you want to represent a Nevada client who has been sued in state court in California, you can do that under this category as long as you are admitted to practice in the California state court. Similarly, if you are a California lawyer and you want to represent a Nevada client who has been sued in state court in Nevada, you can do that under this category as long as you are admitted to practice in the Nevada state court, which admission would be pro hoc vice because you are not a member of the Nevada bar. While it's nice to have this rule, it really only serves to confirm that litigators who are admitted to practice in the court of their state can represent out-of-state clients in those matters, and conversely, that litigators who are admitted pro hoc vice in the courts of other states can represent out-of-state clients in those matters. It doesn't give litigators the right to practice law outside their home state, except when it is related to a specific litigation matter pending before a court in which they are admitted to practice. The third category is Model Rule 5.5C3, and it's also limited for the most part to litigators because it allows representation of a client in this state if the representation relates to a pending or potential mediation, arbitration, or other form of alternative dispute resolution located in this state or in your state. In order to take advantage of this provision, the mediation, arbitration, or other ADR process must relate to the services the lawyer is already doing in his or her state. So, if you're a New York lawyer representing a California client, performing legal work for the client in connection with a dispute arising in New York, you can appear and participate in a AAA arbitration to be held in California without committing the unauthorized practice of law in California under the authority of California's version of Model Rule 5.5, which is California Rule of Court 9.43 and is similar to Model Rule 5.5. You should recognize that this is the same fact pattern that the California Supreme Court dealt with in Burbrower, a New York law firm seeking to represent a California client in a AAA arbitration to be held in California. So now we have Model Rule 5.5C3 that specifically authorizes out-of-state lawyers to participate in mediations and arbitrations held in a state where they are not admitted on behalf of clients in that state. Of course, this leave to participate in a mediation or arbitration is not unlimited, either under Model Rule 5.5C3 itself, which places 2 very important limits on it, or under the other similar rules adopted by states like California that may contain other limits or requirements. The first limit set out in Model Rule 5.5C3 is that the mediation or arbitration must be related to services you are performing for the client in your state. If you are not performing any services for the client in your state, then you are not allowed to take advantage of this provision. The intent here is to prevent litigators from being brought in solely to participate in a mediation or arbitration where they have had no prior involvement with the client or dispute, i.e. a hired gun solely to handle the mediation or arbitration. By contrast, the intent is to allow out-of-state lawyers who have been involved in the dispute from the get-go to continue to be involved as that dispute gets resolved through mediation and/or arbitration. The second limitation in Model Rule 5.5C3 is that the out-of-state lawyer can participate in a mediation or arbitration unless pro hoc vice admission is required to appear in the mediation or arbitration. There are a few possibilities here. If the mediation or arbitration is being conducted by order of a court or pursuant to a judicial referral, it's likely that the rules of that court will require lawyers to be admitted to practice in that court before they can participate in the court-ordered mediation or arbitration. Pursuant to Model Rule 5.5c3, you'll need to determine if your court requires pro hoc vice admission in such circumstances, and if it does, secure that admission before participating in the mediation or arbitration. We'll talk more about the requirements for seeking pro hoc vice admission later. If the mediation or arbitration is being conducted pursuant to the agreement of the parties, either in a pre-existing contract or an agreement made after a dispute arose, and not by order of a court, then it's possible nothing more is required of a lawyer in order to participate. That is the case in New York, where a lawyer can participate in a mediation or arbitration held in New York without any further limitations or requirements pursuant to New York's version of Model Rule 5.5, which is New York Rule of Court 22, Section 523. And it's similar to Model Rule 5.5. That is not the case in California, which imposes some additional limitations and requirements on lawyers participating in mediations or arbitrations beyond what is set forth in Model Rule 5.5. First, under California Rule of Court 9.43, the out-of-state attorney must apply to the arbitrator or arbitral forum for permission to appear and serve a copy of the application on all parties and the state bar. This notice requirement is similar to the notice requirement for seeking pro hoc vice admission in California state courts. Helpfully, there is no express requirement that the lawyer associate with a member of the California bar, or that the out-of-state lawyer not be a resident or regularly practice in California to be allowed to appear before the arbitrator, which is different from the requirements for pro hoc vice admission. Second, California Rule of Court 9.43 requires that the application to appear in the arbitration meet the standards of California Code of Civil Procedure, Section 1282.4, which in turn requires that the application include the name and address of local California admitted counsel who will be the attorney of record in the arbitration, and that the out-of-state lawyer's practice within California be only occasional. While these two additional requirements imposed by California on lawyers seeking to appear in mediations and arbitrations in California are pretty manageable, the fact that New York, which has no additional requirements beyond what is set out in Model Rule 5.5c3, and California, which requires lawyers to jump through a few additional hoops, have differences, illustrates why it is important for you to check the specific rules of the states where you are not admitted and in which you plan to render legal services, even if those states are listed as having adopted rules similar to Model Rule 5.5. The fourth category in Model Rule 5.5c4 is for matters relating to or arising out of your practice in your state and not otherwise covered by these categories. This category is intended to function as a catch-all of sorts, to cover situations where you are working on a matter that's primarily related to your state, but it has effects in other states, and the matter doesn't fall squarely into one of the other categories we've just mentioned, because you're not associating with an in-state lawyer, it isn't a litigation matter, or connected to a mediation or arbitration. This provision provides a safe harbor for lawyers who perform legal work for clients in states where they are not licensed if the primary purpose of your representation of the client is related to your state and the representation of a client outside of the state where you are not licensed. So that's Model Rule 5.5. While the rule is pretty clear, at least as far as ethics rules go, it did raise some questions that the ABA felt obliged to clarify in the commentary to the rule. The first question is whether prior representation of a client is necessary before a lawyer is allowed to practice law outside his or her home state on a temporary basis for that client. The answer to this question is no. The commentary to Model Rule 5.5 makes it clear that prior representation of the client is not required, but it is one of the factors that is relevant to the requirement in Section C3, the arbitration rule, and C4, the catch-all rule, that the lawyer's services arise out of or are reasonably related to the lawyer's practice in a jurisdiction in which the lawyer is admitted. So, if you've represented the client before in connection with matters in your state, that might serve to establish that your services are reasonably related to your practice in your state. Another factor is if the client's previous contacts with your state, or if the matter has a previous connection with your state, and how many other states are involved. I.e., is it just your state and the new state, or there are multiple states involved that might weaken the connection to your state? In any case, the commentary makes it clear that while you can represent a new client for the first time in a state where you are not admitted, if you are doing work for that client on a temporary basis, you are on safer ground if the client and/or the matter has some connection to your state in cases where you are relying on Model Rule 5.5's arbitration, or catch-all provisions to authorize your representation of that client. Let's walk through a few examples to illustrate how Model Rule 5.5 works in practice. Let's say you are a California lawyer who has a long-time California client that has a factory in Nevada. Now, a dispute has arisen with a Nevada vendor. Under Model Rule 5.5c4, it generally would be okay for you to advise that California client on Nevada law and Nevada dispute resolution in connection with trying to resolve the dispute with the vendor. Here, you have a California client, you have a history of prior representation of that client, and you have a lot of connection to California and not as much connection to Nevada. Before you actually participate in a mediation or arbitration in Nevada, you'll need to check to see whether Nevada requires pro hoc vice admission or has other requirements for lawyers appearing in mediations or arbitrations in Nevada. Recall that California imposes some requirements while New York imposes none, to make sure you comply with Nevada's version of Model Rule 5.5c3 if you are seeking to rely on the arbitration rule. Let's consider a different scenario. You have a new Nevada client who has a dispute with a Nevada vendor. There's no contact with California. You may have an issue there. While it's permissible to have a new client, it doesn't have to be somebody you've represented before. But the fact that the client has no contact with California, the only contact is with Nevada, and it involves not only a Nevada client, but a Nevada counterparty. This is the type of case where you want to be more careful, where you are seeking to rely on Model Rule 5.5c4's catch-all provision. Stepping back from the particulars of Model Rule 5.5, it's easy to remember that except in cases where you are associating with an in-state lawyer, Model Rule 5.5c1, and where you are applying for admission pro hoc vice in a litigation matter, that's Model Rule 5.5c2, the other categories of acceptable temporary legal practice in another state require some degree of connection between the clients and/or the matter and your home state. The more connections you have, the fewer concerns you should have about undertaking that representation, and vice versa. More connections mean fewer concerns. If you think about it, all of this is pretty sensible and should help guide you when you're analyzing these issues. The commentary to Rule 5.5 contains two other pieces of guidance that are also very sensible if you think about them. First, recall that Model Rule 5.5 is about authorizing the temporary practice of law in states where you are not admitted. The commentary makes it clear that your practice of law is not temporary if you have systematic and continuous contacts with that other state, even if you are not physically present in that state, or if you hold yourself out as being admitted in that state. Let's say you are a New York lawyer, but you actively solicit clients in New Jersey. You have an office in New Jersey from which you're routinely targeting New Jersey clients, and as a result, most of your clients are in New Jersey and not New York. This is a situation where you likely are unable to claim that you are only temporarily practicing law in New Jersey because you have systematic and continuous contacts with New Jersey, and you are targeting New Jersey clients. This is true even if you prominently display a sign in your office that says you are admitted in New York but not in New Jersey. While of course you can never hold yourself out as admitted in a state where you are not admitted, the mere fact that you have a disclaimer stating that you are not admitted in New Jersey doesn't erase your systematic and continuous presence in New Jersey. Nor does the mere fact that you don't have an office in New Jersey mean that you can't have a systematic and continuous presence in New Jersey. The commentary to Model Rule 5.5 contemplates that a lawyer's presence can be virtual if he or she directs substantial communications to a state for the purpose of soliciting and representing clients there, which, taken together, amount to a systematic and continuous presence in that state. What this very sensible part of Model Rule 5.5 is saying is that if you're targeting a state's clients for representation on a systematic and continuous basis, you need to become a member of that state's bar and can't rely on Model Rule 5.5 to justify a law practice in that state that isn't in fact temporary. The second piece of sensible guidance about Model Rule 5.5 is the recognition that temporary law practice doesn't have a fixed time limit. We all know that litigations tend to last for many months and in many cases many years. The commentary to Model Rule 5.5 confirms that you don't violate the requirement that your law practice in the other state be temporary simply because you continue to represent a client for a long period of time, for example, in a protracted litigation or in connection with a transaction that lasts for a year or longer. Now, if you repeatedly represent the same out-of-state client on one matter after another over a period of a dozen years, and neither the client nor any of the matters has any connection to your home state, that might be too much law practice in the other state to be temporary, and your representation may lack the required connection to your home state if you are relying on the arbitration or catch-all rules. Again, be sensible about your representation of clients in states where you are not admitted, and think in each case whether your legal work is fairly considered temporary and sufficiently connected to your home state. Let's move on to Model Rule 5.5d, which is the part of the rule that deals with in-house counsel. Here's the rule, quote, "A lawyer admitted in another United States jurisdiction or in a foreign jurisdiction, and not disbarred or suspended from practice in any jurisdiction or the equivalent thereof, or a person otherwise lawfully practicing as an in-house counsel under the laws of a foreign jurisdiction, may provide legal services through an office or other systematic and continuous presence in this jurisdiction that 1. Are provided to the lawyer's employer or its organizational affiliates, are not services for which the forum requires pro hoc vice admission, and when performed by a foreign lawyer and requires advice on the law of this or another U.S. jurisdiction or of the United States, such advice shall be based upon the advice of a lawyer who is duly licensed and authorized by the jurisdiction to provide such advice, or 2. Are services that the lawyer is authorized by federal or other law or rule to provide in this jurisdiction." What this says is that a lawyer admitted in another jurisdiction, including in a foreign jurisdiction like Canada or the United Kingdom, and not disbarred in any jurisdiction, may provide legal services in this jurisdiction that are provided to the lawyer's employer or its affiliates as long as they are not services for which the forum requires pro hoc vice admission. So if you are an in-house lawyer, you can have a permanent office and provide legal advice to your employer on a permanent basis in a state where you are not licensed unless what you do requires you to seek pro hoc vice admission. The obvious example is an in-house litigator who seeks to appear in court or take a deposition. That lawyer would need to seek pro hoc vice admission to do either of those things in a state where he or she is not admitted. For all other representation of his or her employer, the litigator could rely on Model Rule 5.5d to authorize that representation without the need to become a member of that state's bar. Model Rule 5.5d also allows lawyers engaged in federal practice, think assistant U.S. attorneys working for the Department of Justice, to have a permanent office and provide legal advice to their employer on a permanent basis in states where they are not admitted. Why do you think we have a different rule for in-house counsel than law firm lawyers? There are two main reasons. The first is that the employers have a strong interest in allowing their employees who are lawyers to be able to work in states where they are not admitted. Otherwise, it would be more difficult for employers to find in-house lawyers to work at its offices located in different states and to move those lawyers around as needed. The second is that the risk of poor representation by these lawyers is limited to their one client, the employer. So the general policy concern about out-of-state lawyers who may not know the laws of this state posing a risk to the general public is not present with in-house lawyers who can only provide legal advice to one client, their employer. It should be obvious, but I'll state it for clarity. An in-house lawyer taking advantage of Model Rule 5.5d can only represent his or her employer and not any other clients, including any individuals, even if those individuals work for the employer. Leave to practice as an in-house counsel means you can only represent one client, your employer, and only for so long as it is your employer. The only other thing to say about the in-house counsel rule is that if you are an in-house lawyer seeking to take advantage of this rule, you need to look at your state's version of Model Rule 5.5d to see what it requires, even if you live in a state that has enacted a rule similar to Model Rule 5.5d. As we will see with California a bit later, California allows in-house counsel to practice in California without being admitted there, but it imposes some requirements and restrictions on those lawyers that are not present in Model Rule 5.5d. On the flip side, I told you earlier that Texas is one of the states that has not adopted a rule similar to Model Rule 5.5, and that is true, but with regard to in-house counsel, Texas gets to the same result by different means. The Texas Board of Law Examiners has issued a policy statement that in-house counsel are not required to be licensed in Texas as long as they are licensed and in good standing in another state and are in-house counsel. So while Texas does not have a Model Rule 5.5, in-house lawyers can practice in Texas as long as they meet the same requirements as Model Rule 5.5d. Let's move now to Model Rule 8.5. This rule is about disciplinary authority and how lawyers are now expressly subject to discipline when they practice in states where they are not admitted. Here is the first part of the rule. Quote, A, disciplinary authority. A lawyer admitted to practice in this jurisdiction is subject to the disciplinary authority of this jurisdiction, regardless of where the lawyer's conduct occurs. A lawyer not admitted in this jurisdiction is also subject to the disciplinary authority of this jurisdiction if the lawyer provides or offers to provide any legal services in this jurisdiction. A lawyer may be subject to the disciplinary authority of both this jurisdiction and another jurisdiction for the same conduct." End quote. Let's unpack this section of this rule in some detail. First, Model Rule 8.5 provides that a lawyer admitted to practice in this jurisdiction is subject to the disciplinary authority of this jurisdiction, regardless of where the lawyer's conduct occurs. So, if you are a California lawyer, you are always subject to the disciplinary authority of California, even when you are performing temporary legal services in another state pursuant to the authority granted by Model Rule 5.5. Put another way, you can never escape the disciplinary authority of the state or states in which you are a member of the bar. Second, Model Rule 8.5 provides that a lawyer is now also subject to the authority and jurisdiction of the state bar in the state or states where your practice of law occurs. In my example, a California lawyer performing temporary legal services in New York for a New York client is now expressly subject to the jurisdiction and disciplinary authority of the New York State Bar, in addition to the disciplinary authority of California. This solves the problem we identified early on about how does another state's bar have the authority to discipline a lawyer who is not admitted in that state. Model Rule 8.5 now grants each state that authority, and you are bound by it as long as you are admitted in one of the 46 states and the District of Columbia that have adopted Model Rule 8.5 verbatim or a rule similar to Model Rule 8.5. As a bright lawyer, I'm sure you've already anticipated my next point, which is, if I can be subject to two or more states' ethical rules, and because the ethics rules can vary in material respects state to state, doesn't this raise the possibility of conflicts? The answer to that is a resounding yes, and Model Rule 8.5 itself attempts to resolve certain of those potential conflicts with Section B, entitled Choice of Law. Here is what that rule says, quote, B, Choice of Law. In any exercise of the disciplinary authority of this jurisdiction, the rules of professional conduct to be applied shall be as follows. 1. For conduct in connection with a matter pending before a tribunal, the rules of the jurisdiction in which the tribunal sits, unless the rules of the tribunal provide otherwise. And 2. For any other conduct, the rules of the jurisdiction in which the lawyer's conduct occurred, or if the predominant effect of the conduct is in a different jurisdiction, the rules of that jurisdiction shall be applied to the conduct. A lawyer shall not be subject to discipline if the lawyer's conduct conforms to the rules of a jurisdiction in which the lawyer reasonably believes the predominant effect of the lawyer's conduct will occur. End quote. Let's break this part down. First, if a lawyer's conduct is in connection with a matter pending before a tribunal, it is the rules of the jurisdiction in which the tribunal sits that will govern. So, if you are representing a client in connection with a lawsuit pending in the U.S. District Court for the Southern District of New York, it is the rules of that court and the legal ethics rules of the state of New York that will govern your conduct. Second, for all other conduct, it is the rules of the jurisdiction in which the lawyer's conduct occurred, or if the predominant effect of the conduct is in a different jurisdiction, the rules of that jurisdiction will govern. So the standard here is where the lawyer's conduct occurred or where it has its predominant effect, which is similar to the test for exercising personal jurisdiction over a defendant in a tort action that is pretty familiar to many lawyers. That said, parties litigate all the time over where tortious conduct occurred versus where it has its predominant effect, so this test, while familiar, may not yield a clear result in all cases. The good news is that Model Rule 8.5b2 also includes a safe harbor, which is, quote, a lawyer shall not be subject to discipline if the lawyer's conduct conforms to the rules of a jurisdiction in which the lawyer reasonably believes the predominant effect of the lawyer's conduct will occur, end quote. So if you make a reasonable mistake of fact about which jurisdiction's law should apply to your conduct, but you conformed your conduct to the ethics rules of that state, you cannot be disciplined for having picked the wrong state. Let's take a case where you're practicing law in Nevada. You're not admitted in Nevada, you're admitted in California, but you take care to follow the rules that apply to Nevada lawyers. Then at some point later, a court determines that in fact the predominant effect of your conduct really took place in California, and so California rules applied. And then whatever the issue is, there's a conflict between the ethics rules of California and Nevada on that point. Model Rule 8.5 makes it clear that as long as you are following the rules of Nevada and you reasonably believe that the Nevada rules applied, you should not be subject to discipline in that scenario, even if it turns out California's rules were applied and there is some conflict that would lead to a violation. That's Model Rule 8.5. Let's switch gears now and talk about the specific rules that California and New York have adopted that govern multi-jurisdictional practice, on the assumption that this discussion will be helpful to those lawyers who are admitted or seek to represent clients in one or both of those states. Starting with California, as we saw with the ABA, the California Supreme Court's decision in the Burbrower case set off a flurry of concern that led the California Supreme Court to issue California Rules of Court 9.45 to 9.48 that were initially adopted in November 2004. Rule 9.45 deals with legal services attorneys, Rule 9.46 deals with in-house counsel, Rule 9.47 covers litigators, and Rule 9.48 covers transactional lawyers. We'll talk about Rules 9.45 and 9.46 together as they share some common requirements. In order for an out-of-state lawyer to practice in California as a legal services lawyer or as in-house counsel, you first have to be a member in good standing of your state's bar. This is all about allowing attorneys who are admitted in one state and good standing members in one state to temporarily practice law in another state. But you can't get anywhere if you're not already admitted and in good standing in your home state. Next, you must register with and pass a character examination by the California State Bar, fulfill continuing legal education requirements, and of course, pay some fees to the California State Bar. Basically, California requires these lawyers to do everything you would have to do in order to be admitted in California, except to take the California bar exam. California has a notoriously difficult bar exam, remember before the famous lawyers who failed it. So that dispensation is no small thing, but the point to remember is that unlike Model Rule 5.5d, which doesn't require anything except membership in good standing of another state's bar, California piles on a few more requirements before you may practice law as a legal services lawyer or an in-house counsel in the Golden State. Don't forget, like most states, California is willing to accept out-of-state lawyers practicing in California as part of a nearly uniform framework that grants its own lawyers the same privileges in most other states, but it still doesn't want to open the floodgates to out-of-state lawyers who want to practice in California but who don't want to take the California bar exam. Rules 9.45 and 9.46 are hurdles intended to prevent unchecked migration of lawyers into California, or at least speed bumps to slow that migration down. You also should recognize that once you register as a legal services lawyer or an in-house counsel in California, you are expressly subject to the disciplinary authority of the California State Bar, in addition to the disciplinary authority of your home state pursuant to Model Rule 8.5. Rule 9.45 includes some specific limitations for legal services lawyers, such as the lawyers who work as public defenders or for organizations that provide civil legal services. First, you may only work for a legal services organization, but the rule does permit that organization to represent individuals. So if you work for a public defender service, the service may represent individuals, and effectively you will be the lawyer for individuals as a staff attorney with that service. But Rule 9.45 does not allow you to represent any individuals directly, such as a friend who may be involved in a criminal matter. Your representation is limited in scope to your work with the legal services organization and with the organization as your client, recognizing that the organization may have individual clients without violating Rule 9.45. Second, you must at all times be supervised by an experienced California attorney. Of course, most legal services organizations are structured that way, where you have more junior lawyers who are supervised by more senior lawyers. But that is in fact a requirement for you to be able to work in California under Rule 9.45. Third, your leave to practice as a legal services lawyer is limited in duration to 3 years, after which you are required either to cease your practice or to sit for the California bar exam. In essence, Rule 9.45 is intended to benefit young lawyers, probably lawyers who are right out of law school and who have not yet sat for or passed the California bar, who are working in legal services organizations and who are very carefully supervised by more senior lawyers for a period of up to 3 years, before they then must sit for the California bar and be admitted like everyone else. Similarly, Rule 9.46 includes some specific limitations for in-house lawyers. First, you may only represent your employer and you may not represent any individuals. Generally, this should not present a problem for in-house lawyers because in nearly all cases, your client is the company and not any individual employee, officer, or director of the company. In rare cases where an in-house lawyer might represent an individual, that is not permitted if you are an out-of-state lawyer working as an in-house lawyer under the authority of Rule 9.46. Second, Rule 9.46 states that in-house lawyers can't make any court appearances. If you are a litigator or general counsel who would like to appear in court, you would have to go through the formal pro hoc vice process, which may or may not be available to you, or may not be a practical solution for in-house counsel due to the requirements it imposes that we will discuss later. Bottom line, if you are an in-house litigator who seeks to take an active role in litigation, Rule 9.46 may not provide enough flexibility for you, and you may need to become a member of the California Bar in order to practice effectively. Third, and unlike the rule for legal services lawyers, in-house counsel can practice indefinitely under Rule 9.46, although you must renew your registration annually and, as noted, fulfill your CLE requirements and pay your fees. So no free ride for out-of-state lawyers, but also no fixed time limit on how long you can practice as an in-house lawyer in California. Let's move now to Rule 9.47 that covers litigators and Rule 9.48 that covers transactional lawyers. As we saw with the other two rules, Rules 9.45 and 9.46, these two rules share some common requirements. First, as we saw before, in order for an out-of-state litigator or transactional lawyer to practice in California, you have to be a member in good standing of your state's bar. Second, and this is different from the earlier rules, you must have an office outside California and you must not have a California residence or substantial business in California. The idea is that you don't want lawyers who live in California, have an office in California, and represent mostly California clients taking advantage of a rule for out-of-state lawyers. If you are doing all of these things, you are a California lawyer and you need to be admitted in California. If, on the other hand, you live in New York, your office is in New York, and you don't have any offices in California, and you happen from time to time to represent a California client on a limited matter, Rules 9.47 and 9.48 will allow that. Third, you must indicate on your website and in any advertisements that you are not admitted in California. This requirement ensures that you are not holding yourself out and that clients don't believe that you're admitted in California when you're not. Although neither requires you to register with the State Bar of California, unlike Rules 9.45 and 9.46, you should recognize that by practicing law in California pursuant to Rules 9.47 or 9.48, you are subjecting yourself to the disciplinary authority of the California State Bar, in addition to the disciplinary authority of your home state pursuant to Model Rule 8.5. Apart from these general requirements, Rule 9.47 includes another specific limitation for litigators. Your legal services must be performed in anticipation of filing a lawsuit in California or in a state in which you are reasonably expected to be entitled to appear, i.e. a state where you were admitted, or a court where you expect to be granted leave to appear pro hoc vice, or part of a lawsuit already pending in a state in which you are entitled to appear. In cases where the lawsuit in California is pending, authorization to perform legal services ends when that lawsuit is filed, after which you are required to seek pro hoc vice admission in order to continue to participate in that case. The idea here is that if there's pre-litigation going on in California and you expect that a lawsuit will be filed in California, or there's an existing lawsuit in your home state of New York, that you will be allowed under Rule 9.47 to participate in settlement negotiations or attend a deposition in California. However, once a case is filed in California, Rule 9.47 requires you to seek pro hoc vice admission so as not to supplant the existing pro hoc vice admission system and requirements. So, if you're actively going to participate in a lawsuit that's been filed in California, you do have to go through the normal pro hoc vice admission process, and Rule 9.47 is not a substitute for that. Rule 9.48 includes two specific limitations for transactional lawyers, thankfully neither of which is particularly onerous. First, your legal advice must be limited to a transaction or other non-litigation matter. Second, a material aspect of the transaction or other matter must take place in your state, or the advice relates to an issue of federal law or the law of a state other than California. So, Rule 9.48 affords transactional lawyers a broad license to provide legal advice to California clients, in that it applies to anything non-litigation, and can include advice on California law as long as the material aspect of the matter relates to your own state or relates to other states or federal law, which is a pretty easy standard to meet as long as we're talking about a reasonably complicated transaction or other matter. Those are the California rules of court that collectively implement Model Rule 5.5 for California lawyers. As you can see, the rules are pretty similar to Model Rule 5.5, but there are differences that may be important depending on your circumstances, which is why we reviewed them here. There is one critical difference that we haven't mentioned between the California Rules of Court and Model Rule 5.5, which is that California has no equivalent of Model Rule 5.5c1, which is the provision that gives out-of-state lawyers the option to associate with a local lawyer. The only bases on which an out-of-state lawyer can legally practice law in California are the ones set out in Rule 9.45 for legal services attorneys, Rule 9.46 for in-house counsel, Rule 9.47 for litigators, and Rule 9.48 for transactional lawyers. If your representation doesn't fall into one of these categories, or if you don't meet the requirements of that category, you are engaged in the unauthorized practice of law in California. Interestingly, if you are doing this while being associated with a California lawyer, the California lawyer could be violating the ethics rules by aiding and abetting you in the unauthorized practice of law, which could subject that lawyer to discipline. So this is an important thing for you and any California lawyer with whom you work to know. Let's turn our attention now to the Empire State. Unlike California, New York has a rule of court that more closely tracks Model Rule 5.5, that's Rule 523. although New York, like California, also has separate rules that govern legal services attorneys, Rule 522.8, and in-house counsel, Rule 522.1. In general, Rule 523 tracks Model Rule 5.5 pretty closely, and if you are in compliance with Model Rule 5.5, you will be in compliance with New York Rule 523. Here are 3 key points to keep in mind about New York's Rule 523. First, New York, unlike California, but like Model Rule 5.5, does allow out-of-state lawyers to associate with a New York lawyer who actively participates in and assumes joint responsibility for the matter for the purpose of performing temporary legal services in New York. Second, New York allows out-of-state litigators to participate in a mediation, arbitration, or other ADR process, and unless that process is being conducted in connection with a New York lawsuit, no pro hoc vice admission is required. Third, like California and Model Rule 5.5, practicing law in New York pursuant to Rule 523 subjects you to the disciplinary authority of the New York State Bar in addition to the disciplinary authority of your home state pursuant to Model Rule 8.5. New York's separate rules for legal services attorneys, Rule 522.8, and in-house counsel, Rule 522.1, vary a bit from California, so it is worth reviewing those differences. Other than the differences I'm going to highlight, the rules are more or less equivalent, but of course it behooves you to review them in detail if you plan to rely on them to authorize your practice of law in New York. Under Rule 522.8, legal services lawyers in New York are required to register as in-house counsel, and when they do, they are allowed to appear in court without seeking pro hoc vice admission, at the court's discretion, as long as they notify the court that they are not admitted in New York. Unlike legal services lawyers in California, legal services lawyers are not subject to special supervision requirements, nor does their leave to practice law expire after 3 years. Under Rule 522.1, in-house lawyers in New York share the same requirements and have the same benefits as in-house lawyers in California, with just a few differences. New York allows foreign lawyers, i.e. lawyers who are admitted in another country, such as Canada or the United Kingdom, to register as in-house counsel, whereas California permits such lawyers only to register as foreign legal consultants. Foreign legal consultants are limited to giving advice relating only to the laws of their home jurisdiction and not to the law of the U.S. or any U.S. state, versus registered in-house counsel in New York or California who can give advice on the law of any U.S. state or federal law. New York also allows in-house counsel to represent individuals as long as they are employees, officers, or directors of the lawyer's employer, and as long as the representation is in connection with matters relating to the lawyer's work for the employer. In other words, the in-house lawyer can advise an employee on matters relating to his or her work at the company, but not any personal matters. Let's turn to our final topic, associating with local counsel in connection with a transactional or litigation matter, or applying to a court for permission to appear pro hoc vice, which means, for this matter only, in a litigation matter. What obligations does an out-of-state lawyer who associates with or is sponsored by for pro hoc vice admission by local counsel in a state where he or she is not admitted for the purpose of performing legal services in that state? The first thing is to understand the local state's rules and requirements and to comply with them. For example, we learned earlier that despite adopting rules similar to Model Rule 5.5, California does not permit out-of-state lawyers to associate with local lawyers, and in fact, if the out-of-state lawyer's conduct doesn't fall into one of the recognized categories or exceptions, that lawyer is engaged in, and the associating lawyer is aiding and abetting, the unauthorized practice of law. So that would be a critical thing to know. Of course, California does permit pro hoc vice admission by application, which is governed by Rule 9.40. The out-of-state lawyer must be a member in good standing of her home state, she must not be disbarred in any state, she must include in the application a California lawyer as the attorney of record, pay a fee, and serve a copy of the application on the State Bar of California at the same time that it is filed with the court to which the application is made. The court has the discretion to grant or deny the application, and Rule 9.40b provides that absent special circumstances, repeated pro hoc vice appearances by a lawyer is cause for denial of a pro hoc vice application. The fact that lawyers have to serve a copy of each pro hoc vice application on the State Bar of California helps the State Bar and the courts track lawyers who are making repeated pro hoc vice appearances. The court also should reject a pro hoc vice application under Rule 9.40 if the lawyer resides in California, is regularly employed in California, or is regularly engaged in substantial business, professional, or other activities in California. If this is your situation, California is telling you that you need to become a member of the California Bar and cannot use the pro hoc vice system to appear in California courts. New York also allows pro hoc vice admission, which is governed by New York Rule of Court 520.11 and is granted, quote, in the discretion of any court of record to participate in any manner in which the attorney is employed. end quote. The only real requirement is that the lawyer associate with local New York counsel for the duration of any pretrial and trial proceedings. Importantly, and unlike California, New York does not have a non-residency requirement, so you can apply for admission pro hoc vice in a New York court even if you live and work in New York. Nor is there an express prohibition on admitting lawyers pro hoc vice simply because they repeatedly have been granted leave to appear pro hoc vice in the past. Finally, New York allows foreign lawyers to be admitted pro hoc vice, again at the discretion of the court to which the application is submitted, unlike California that permits only U.S. lawyers to apply for pro hoc vice admission, similar to its limitation that only U.S. lawyers can register as in-house counsel. New York also allows out-of-state lawyers to associate with local New York counsel as contemplated by Model Rule 5.5, which is governed by New York Rule of Court 523.131. There are no application or registration requirements for association with local New York counsel under Rule 523.131. As you might expect, in cases where a lawyer is associating with local counsel in New York, or been granted leave to appear pro hoc vice in New York or California, that lawyer agrees to follow the rules of the court in which the lawyer is appearing, if applicable, as well as the ethical rules of that state, and to be subject to the disciplinary authority of that state's bar. So we've covered association with local counsel and admission to practice pro hoc vice from the perspective of the out-of-state lawyer. Now let's review the obligations that apply to the local lawyer who is associating with or sponsoring for pro hoc vice admission the out-of-state lawyer. In the former case, Model Rule 5.5 requires the sponsoring lawyer, quote, to actively participate in the matter, and New York's Rule 523.231 requires that the sponsoring lawyer, quote, actively participate in and assume joint responsibility for the matter, end quote. Thus, it's clear that a sponsor cannot be a sponsor in name only, and that the sponsoring lawyer must actively participate in, and in New York also take responsibility for, the matter in which the out-of-state lawyer is participating. Obviously, this is intended to ensure that the client receives quality representation in cases where an out-of-state lawyer is providing his or her services. For pro hoc vice admissions, the attorney who sponsors the out-of-state lawyer similarly must be, quote, the attorney of record in the matter, end quote, under both New York Rule of Court 520.11c and California Rule of Court 9.40. In essence, as sponsoring counsel for a lawyer who is granted leave to appear pro hoc vice, you are the attorney of record and thus are responsible for all aspects of the matter as if there were no other counsel. Put another way, you will not be able to disclaim responsibility for a failure to represent the client adequately, for example, if a filing deadline is missed, by pointing to the actions or inactions of pro hoc vice counsel, since the obligation to meet filing deadlines ultimately rests with you as the attorney of record. To summarize, it's never okay for the local lawyer to associate with or sponsor an out-of-state lawyer if the local lawyer has no involvement in the matter on which the out-of-state lawyer will work. The ethics rules require, quote, active participation, end quote, and in some states, quote, joint responsibility, end quote, for the matter. And in the case of pro hoc vice admissions, the local lawyer remains the attorney of record for the client and as such bears all responsibility for any failure to provide the client with adequate legal representation in the matter. If you fail to live up to these requirements, and if by allowing out-of-state counsel to operate without your close supervision and something goes wrong, state bars will not hesitate to hold you responsible for that. Nor will judges hesitate to come down hard on you in litigation matters, where an out-of-state lawyer you sponsored for pro hoc vice admission isn't following the court's rules or is otherwise not living up to the court's expectations of counsel. So you need to think twice before agreeing to associate with or sponsor out-of-state counsel, and if you decide to do it, you cannot abdicate your supervisory role and must remain actively involved in the matter. If you don't, you might receive a referral to the state bar to answer for ethical violations allegedly committed by the out-of-state lawyer, and possibly even a charge of aiding and abetting the out-of-state lawyer in the unauthorized practice of law if, for example, the lawyer was holding himself out as admitted to practice law in your state and you didn't do anything to correct those assertions. In cases where similar charges were proved, state bars have imposed fines, suspensions, and even disbarments of sponsoring lawyers. And in litigation matters, courts have imposed litigation sanctions, fees, and costs against those lawyers. In some cases, judges have revoked a local lawyer's pro hoc vice privileges, meaning that the lawyer would not be permitted in the future to sponsor an out-of-state lawyer pro hoc vice because the local lawyer allowed a prior sponsoree to commit ethics violations. You certainly don't want to suffer any of these consequences because you failed adequately to supervise an out-of-state lawyer you sponsored. I hope you enjoyed today's presentation. Thanks for watching.